Okay, so federal diversity jurisdiction, so one of the theories of that is that if you have a lawsuit involving people in two different states, it crosses a state line, and therefore federal law comes into play. All right, so 10 types of jurisdiction. Trial court jurisdiction, original jurisdiction, appellate court jurisdiction, exclusive jurisdiction, concurrent jurisdiction, personal jurisdiction, subject matter jurisdiction, in rem jurisdiction, federal diversity jurisdiction, and federal subject matter, federal law jurisdiction, federal question jurisdiction. Okay? 10 of them. I want you to be able to list out up to 6. Fill the blank. Now, I also want you to be able to try to figure out which court has jurisdiction if I give you a little example. So let me show you what I'm talking about. So we're going to go back to this map here that has all the different counties. So this is a case I had here a few years back. My client was a helicopter pilot, and he lived up in McMinnville, north of here, about, what, 25 miles or so, right? Up in Yamhill County. So he worked for a company up there, a helicopter company, that was also headquartered in Yamhill County up in McMinnville. And his job with helicopters, he did all kinds of stuff, but primarily he would fly the helicopters in logging operations. And so they'd be out in the woods during a logging operation, they'd cut the trees down, they'd pick the trees up with the helicopter and fly them over and drop them in an area where then they put them on a log truck and send them off to the mill, right? Happens here in Oregon all the time. You see it all the time. So in this particular circumstance, our guy from Oregon was down in Georgia, about right there. A little tiny county in Georgia. Blow that up for you real quick. Like right in here somewhere, okay? Little itty bitty county. And they're doing a logging operation down in Georgia, right here. And they got finished with the logging operation, so they're going to move to another location. And that was about, I don't know, a couple, 300 miles away. And so when they're moving the helicopter that far, they don't fly it. They put it on a flatbed semi-truck trailer, and they truck it. For various reasons, one of which is it's expensive to fly the helicopter, fuel and wear and tear. You also have to pay the pilot flight time, which is more expensive than off-duty time. And then, there's the risk of crash and all that stuff. So long story short, my client, the helicopter pilot from Oregon, is in Georgia, and they're going to move the helicopter. So the pilot, my client, was in the semi-truck cab. He wasn't driving, he was a passenger, basically taking a nap. And the truck driver's driving down the road, coming off the mountain, and a log truck driver comes down and runs through a stop sign and runs into our guy's semi-truck. Now fortunately, they weren't going that fast, like 15 miles an hour. So I mean, this was not a major collision. But still, you're talking one semi-truck running into another. So there's a lot of mass there. So my client, the helicopter pilot, basically got jostled around a little bit. Nothing major, went to the emergency room, nothing broken, basically soft tissue injury, a strain to the neck, which we would call whiplash, right? So he goes to the emergency room in Georgia, is discharged the same day. They give him one of the little neck collar things, right? Flies back to Oregon where he lives. When he gets back to Oregon, he goes sees his normal doctor, goes and sees an orthopedic surgeon. They do an MRI on his neck, everything's fine, other than neck pain because of torn muscles. So 2 months goes by, our guy can't work because he can't fly, because he can't move his head, basically like this, right? And so he can't fly a helicopter like that, he's grounded. So 2 months goes by, and then after about 2 months, he's doing great. gets cleared for duty, goes back to flying, and fully resolved. No permanent injuries, so basically 2 months out of work, okay? So he came in to see me here in Oregon, here in Monmouth, and he wants to sue the truck driver that ran into him in Georgia. That's what we're leading to. So now I've got to figure out, okay, how am I going to resolve this case for my guy? Now, I'm in Oregon, he's in Oregon. We don't really want to have to go to Georgia if we don't want to. So ideally, if we could, we'd love to file the lawsuit here in Oregon. That way we don't have to fly down to Georgia. You know, I like going to Georgia, but you know, my client doesn't want to pay me to go there, and nor do we want to incur all those costs. So if we don't have to file there, we'd prefer to file in Oregon. So the question is, can we? So now let's work our way through jurisdictions. So this is kind of like a question I give you on the test. So first thing we got to look at is the P, then the S. Personal, then subject matter. So first of all, personal. Personal means you have a connection, both parties, to where you filed a lawsuit. So if I file in Oregon, what's the connection with my client? With Oregon. Yeah, he lives there. That's one. He works for an Oregon company. That's two, right? All right, so that's fine, but what's the problem of me filing in Oregon? Georgia truck driver has no connection to Oregon whatsoever. Never been to Oregon, doesn't drive truck to Oregon, doesn't visit Oregon, doesn't really even know where Oregon is. It's like over there on the other side of the United States somewhere. And so there's no personal connection. So if I filed at a court in Oregon, maybe it's the right kind of court, but it's the wrong place. So the court would not have personal jurisdiction, the judge would have to throw it out. So that leaves me with filing where? In Georgia, exactly. Remember, you always want to look first where the location of the event took place, because you will always have, where'd it go? There it is. You will always have jurisdiction where the event occurred, in this case, the accident. All right, so I could file in the state court in the county where this occurred in Georgia. Like right in here. I don't remember which county exactly, but it was like right in here somewhere. So now, I don't really want to file a lawsuit there. Any idea why? They're the same thing in sports.
Home field advantage.
Home field advantage, yeah, we have the same thing in sports, right? What do I mean by that? Well, the truck driver in Georgia, got to know a little bit more about him, and it turns out that he had been, for like the last 25 years, the coordinator for all of the youth sport activities in that county, well, in that whole general area, for like 25 years. So he coordinated like all the fall sports, flag football and soccer, and then basketball in the winter, and then softball and baseball in the spring. And he was also a coach during all of the seasons, so like pretty much any kid that played youth sports knew who he was. Like what, for 25 years. And or was coached by him. Now why does that matter? Who cares about youth sports and semi-trucks? Why does that matter to me as a lawyer?
The judge could have been coached by him.
What was it?
The judge could have been coached by him.
The judge could have been coached by him, but not so much the judge I'm concerned about. Jury, right? 12 people on the jury. Now they may, you know, I'm going to ask them, hey, was he ever your coach or something? But at some point, maybe they weren't coached, but they knew of him and he had a good reputation in the community. Was, you know, everybody liked him. I liked the guy. I mean, he was a nice guy. You know, he just blew through a stop sign. Any of us could do it. So I mean, he'd also been on city council, was a deacon in his church. I mean, just had, you know, a lot of good ties with the community. So long story short, yeah, home field advantage. So I filed a lawsuit in Georgia. My client's from Oregon, or Oregon, right? We're going to get hometown, big time. So I don't really want to file there. So what's my other option? Any guess? What other kind of court would there be in Georgia? So I could file in the state court. Federal, very good. So instead of state court, hey, I'd like to file that lawsuit in Atlanta, Georgia. That's where the federal court's located for the Northern District of Georgia. So to get there, the reason I want to go to Atlanta is nobody's going to know the guy, right? So we're going to have a little bit more of a level playing field. Not as much, but it's going to be more than that little tiny court in that little tiny county. All right, so can I go to federal court? Well, my lawsuit is based on running through a stop sign. That's a state law, right? It's not a federal law. So I've got to meet these requirements to get to federal court in Atlanta, Georgia. So first of all, can I meet the first requirement? Resident of 2 states. You betcha, no problem. My guy lives in Oregon, truck driver lives in Georgia. Piece of cake. Letter B, got to meet that requirement as well. Well, we haven't really talked about that too much. So in that particular case, my client had about $5,000 of medical bills. $5,000 a med. And he lost about 2 months of wages, made about 10 grand a month as a pilot. This is like 15 years ago, so he'd make a lot more now. Pilots get paid pretty good. So about 25K in what we call economic damages. All right? So 25,000. What's the dollar limit I got to get to? 75, very good. 75 plus, right? So somehow, I've got to go from 25 to 75. So I got to come up with $50,001. How do I get that? Any ideas? So this is economic, lost wages, medical bills. What are some ways I could get from 25 up to 75?
Car damage?
Car damage, that's a possibility, absolutely. Now, in our case, it was about like $1,500. It wasn't much, and it had been paid by insurance already, and so it wasn't part of our case, but you're thinking the right thing. What else? The helicopter was not damaged at all.
Travel expense.
Okay, travel expense, good thinking. Costs don't count into that. But yeah, you're on the right track. Okay, back to what you said was whiplash, which we call it a certain kind of damage. It begins with P. Not psychological, but physical, ouch, pain, and suffering.
Oh, okay.
Yeah, you're on the right track. I'm kind of leading you a little bit. Pain and suffering, right? That's called a non-economic damage. So non-economic damages are things that you can't really add up on a calculator. You know, like we can figure out how much money you make per month and add that up, and the bills from the hospital. That's economic. Non-economic is what we call subjective. So pain, emotional, physical impairment, disfigurement. Those are all things that are what we call subjective, meaning they're different depending on the circumstances. So pain, the more painful the injury, and I know this sounds kind of, I'm not sure the word macabre or rude or whatever, but it's true. The worse the injury, the worse the pain, the more money. The worse the disfigurement or permanent impairment, like if you lost the use of a leg, the more money you're going to get in a lawsuit. That's just how it works. It's not necessarily the right way to do things.
Something that didn't happen, you can just go over there and get more money. I mean, it happened, but just the factuals of what it is.
Right. So yeah, that's what we got to look at. What was the pain? So the question is, okay, can I get $50,000 from a jury? Would a jury be willing to award $50,000 for a person who had a neck pain that fully resolved after 2 months, nothing permanent? Is that worth 50 grand?
I mean, they don't know, but.
Right, yeah. Well, let me ask you a different way. Question?
Well, I was saying, like, can it factor into the pilot, was the pilot able to, I'm sure he's getting paid more working out of state. Was he able to maintain?
Yeah, they put him on workers' comp, so he got paid.
Well, I was saying, like, but he wasn't able to continue working out of state at that point.
As soon as his neck pain went away,
Yeah.
yeah, he was cleared to fly anywhere. So he can we
But
got,
did he though? Is what
yeah,
I'm saying.
he did.
Oh,
He
okay.
went back to work, yeah. He loved flying. He was ex-military, he was a great pilot.
And he was ex-military. See, that might hit some people right there.
Well, he, you know, that factors into the wage amount.
Okay.
Yeah. So, but here's what I'm getting at. Okay, neck pain, is that worth 50 grand? So let me ask you, let me flip it around. Let's say you're on the jury now. If I offered to pay you $40,000 cash, non-taxable, to have a pain in the neck for 2 months that fully went away.
Not having the pain, I'm talking about ours.
Yeah, okay, 30 grand? Yeah, you got 30, you guys take 30. And you take like a couple of top ramens and a Subway coupon, right? You're college students. 10 grand? That's where I think probably we're starting to, right? So you see what's happening there? A judge is gonna look at that and say, okay, 2 months of neck pain is not worth $50,000. No reasonable jury is gonna get $50,000 for, 2 months of neck pain. And so, in other words, I can't, in good faith, meet this requirement, because I've got to show the judge in federal court at a very threshold level that there's sufficient injury to merit that amount of money. So in our case, we couldn't do that. So we ended up having to file, where? State court right there in Georgia. Now, we settled that case for a lot less than probably if we could have gone to federal court. Because the insurance company, that's who we settled with. They know that, right? They've got lawyers. So the point I'm making is not so much the dollar amounts or anything like that. The point is, this is how you, real world, jurisdiction, right? You narrow down where you're going to file a lawsuit. In this case, it was one court. What kind of jurisdiction we call that? Only one? Exclusive, right. Okay, let me change the facts now, okay? Remember questions of fact? So now let's say instead of just some neck pain, the guy was paralyzed for a couple of years, or maybe the rest of his life, even worse. Could never fly again, or had permanent impairment of his arm, so he couldn't fly anymore, so he's grounded. So at the time he was about, if I remember, just about 40 years old, 42, somewhere in there. So he had at least another 10 years of work, if not more, as a pilot. So basically 10 years of lost wages times 120,000 a year, that's $1.2 million. Plus you're going to give like maybe a 3 to 5% annual increase for CPI. So now, let's say it's $1 million case. Now where can we file a lawsuit? Federal, where? In Atlanta. Or state court in that little county. Now let's also change it and say that the truck driver was actually working for an Oregon company, and those logs were going to be shipped out to Oregon, and that truck driver drove back and forth to Oregon every month.
Would it still be Georgia because we're happy?
I think it would, yeah. But theoretically, we could also file in Oregon. Now, if that were to happen, like exactly what you're saying, the judge in Oregon is going to say, you know what, that happened in Georgia, even though technically, you're going to send it back to Georgia.
Well, I cover the same lines of that. What if it was like a nationwide, it was a nationwide company?
Like Microsoft or something, right?
Or like Maytruck or?
Yeah, or Pfizer or whoever, yeah.
Yeah. Would that play through? I mean,
Absolutely,
yeah.
because now we're talking about the defendant, where they can be sued.
Right, because
Yeah,
you're not
so
suing,
Maytruck either
not
nationwide.
the driver, you're suing the company. So you
Yep.
could, yeah.
Because we're going to sue the driver and the company.
So there'll have to be two different courts?
No, the same court case, yeah. You sue them, the reason why you sue the driver separately from the company is in case the driver was doing something that the company did not authorize, they can claim it was outside the course and scope of their employment. And in that case, only the driver would be liable. Now, in commercial trucking, the trucking company's going to be liable as a matter of law.
But then in that case situation, you could sue Oregon, or you have to go back to Georgia?
We could sue in Oregon in that
But
case.
I can keep back.
Yeah, but what the court would probably do is say, you know what, yeah, there is jurisdiction here, but it's called a forum non-convenes, which is a non-convenient forum. And the most convenient forum is where it occurred. Because you're still going to be applying Georgia law. So it'd be kind of weird for an Oregon court to apply Georgia law. Technically, they could do it, but the judge is here to say, we don't want to deal with that. Okay, so long story short for you guys, let me just recap, okay, because we went through a lot. So here's what I want you to know for the midterm. Are you ready? Number one, be able to fill in the blank question. Fill the blank. What are up to 6 types of jurisdictions? So there are 10 we went through. You pick the 6 that you like. Fill in the blank. True, false, multiple choice question. Question would be something like, true or false, if I want to file the lawsuit, I can start in an appellate court. False. It's the wrong kind of court. You have to start in the trial court. True or false, I can file a federal diversity jurisdiction case even if it's only worth $10.
False.
False. So those are the kind of questions. Multiple choice would be something like, of these courts, which one do I have to file a lawsuit in? A Supreme Court, which is an appellate court, a Circuit Court of Appeals, Oregon Trial Court, or a federal circuit court, or a state appellate court. Which one do I have to file? Trial court, right?
Yeah.
Gotta file a trial court. Okay, let's move on. Page 24. So this is another possible fill in the blank question. I put it at 80%, probably a little higher than that actually, but pretty easy for you guys to remember, so we'll go with 80%. It depends on what I feel like putting on the test this particular term, but this is a pretty common question for me. Here's the question for fill in the blank. List 4 courts that involve the state of Oregon, or 4 courts in Oregon. So this is a list of the various courts we have that either are Oregon state courts or involve the state of Oregon in some way at the federal level. So let's start here under Oregon state courts. So first of all, we have small claims court. Small claims court is designed to allow people to file a lawsuit on their own without lawyers. The maximum dollar value is $10,000. And the idea being that these are smaller level cases, people need to get a lawyer and incur the cost of an attorney. It's highly abbreviated in terms of procedures. Frankly, I think it works pretty well. I actually refer my own clients to small claims all the time. I don't want to deal with small cases either, so that's part of that too. They don't want to pay me on those small cases. So it's a trial court. That's why I have the T right here for trial, which means you got to produce evidence to prove your case. So witnesses and photographs and whatever when you go to the court, right? All right, next we have what's called a municipal court, a city court. So in Monmouth, for example, we have Monmouth Municipal Court. Some of you may have been there. You got a ticket or something here in Monmouth. Or you have a party and the noise was too loud, right? Nuisance violation. They ticket those all the time. We have county courts, which we call it, sometimes they're called a justice court. These are operated by a county, like in Marion County. We don't have one in Polk County, but Marion County has a justice court in Woodburn and State, and they deal with county law. So city law, county law. So zoning, animals at large, speeding and traffic tickets at the county level. And that leads us, and that's trial court as well. Then that leads us to number 4. A circuit court. Now I have this one highlighted because I want you to know that this is the name of the primary trial court for the state of Oregon system. The state of Oregon Circuit Court in each county. So here in Polk County, we have the Polk County Circuit Court for the state of Oregon. In Salem, what do you suppose it's called?
Salem, Court of.
What county is Salem?
Okay.
Marion County, yeah, Marion County Circuit Court for the state of Oregon. Okay, downtown Portland. Multnomah County Circuit Court, the state of Oregon. Hillsborough, Washington County Circuit Court, state of Oregon. Oregon City, Clackamas County, Corvallis, Benton County, you get the idea, right? That's the primary trial court at the state level, okay? So if I'm going to sue somebody in state court, typically I'm going to file that lawsuit in the county where it occurred, for the circuit court for the state of Oregon. Criminal, same thing. You can have crimes all the way up to felonies, aggravated homicide, murder. At the lower level, only misdemeanors.
So if we was to attend a trial court, it'd be the circus court for here.
In Dallas, but yeah,
But
in Polk County, yeah, you're right. Okay, yeah, question.
Okay, well, for example, like, you said primary trial court, so like if you got like arrested for DUI, right,
Okay.
in Monmouth.
In Monmouth, right, so you're gonna go to Monmouth Circuit, it's municipal court for that. Because it's a crime that occurred within city limits, and it's not a felony.
But you still go to trial, right?
Still have a trial.
Yeah,
Yeah.
okay.
Now, you can actually ask to have it moved to the circuit court if you want.
Oh, okay.
Yeah. All right. From there, our first level of appeal is the Oregon Court of Appeals in Salem. That's an appellate court. And then the highest level court we have in Oregon is the Oregon Supreme Court, which is the Court of Appeal. All right, federal court. So the federal court, the trial court, which I have highlighted here, that's why I have it highlighted, I want you to know that. The name of the primary trial court in the federal system is called the Federal District Court for whatever state you're in, whatever part of the state. So in Oregon, it's the Federal District Court for the District of Oregon. We only have one district in Oregon. We have, the courts are actually located in different places, Portland, Eugene, they also go to Pendleton, sometimes Burns. Some states have more than one district, like Washington has two, the Western and Eastern District. California has 4 districts because of population. So I just want you to know the name of the primary trial court in the federal system is the Federal District Court. Bankruptcy court is also a trial court where you produce evidence. That is an offshoot of the district court. And then we have the first level of appeal at the federal level. We are in the 9th Circuit Court of Appeals, which is located in San Francisco. And I'll show you that in a moment. And then at the highest level, of course, is the United States Supreme Court in Washington, D.C. Down below here, which is an appellate court. And then down here, we have other tribunals or whatever. We have tax court in Oregon for like income tax, excise tax, things like that. And then we have, if administrative law is at issue, it's called administrative law judge. Sometimes they call it a hearings officer. For like if your driver's license is suspended, you can have a hearing on that. Or if you get an environmental fine through DEQ, or if you're a contractor, you get a fine from the CCB, Construction Contractors Board, etc. All right, so for you guys, here's what I want you to know for the midterm. First of all, be able to list 4 fill-in-the-blank courts involving the state of Oregon. Second, I want you to know which are the primary trial court in the state system. It's the state circuit court. Federal system, federal district court. That'll be more of true false for multiple choice. All right. Where's that federal map? Go back to page 22 just real quickly. This is a map of the federal system, sort of. So again, we have district courts in each district, or each state. Oregon only has 1. See here, Washington, there's that line. So we have the Western and Eastern District. So that's the district trial courts. Then we have these dots. Those represent what we call the circuit courts of appeal. So remember, we are in the 9th Circuit right here, the 9th Circuit, which basically means any cases that come from the West on appeal go to the 9th Circuit Court of Appeals, which is located in San Francisco. Although they do sometimes do court in Portland and Seattle as well.
You said San Francisco?
Yeah.
What is the Court of Appeal?
Okay, the Court of Appeal reviews to make sure a lower level court did things correctly. So it's like they're going to make sure a judge below them made the right decision. It's like in sports, when they watch the video, a replay, to make sure that the referee made the right decision during a game. So they're like the video review. Does that make sense? Kind of? All right, so we see here we have 11 numbered circuits, and then we actually have 2 more in Washington, D.C., the Federal Circuit, and Circuit for the District of Columbia. So that's where you, like you hear in the news, the 9th Circuit, that's what they're talking about. Like the 9th Circuit ruled that, That's what they're talking about, yeah.
Where did the 8th and 9th Circuit break off at? Like,
Yeah, I don't remember if it's, I want to say it's here. I think Montana's in the 8th Circuit. I don't remember off the top of my head exactly. I know, this is actually a color one. Do you remember where the 9th Circuit is? I can't remember if it's Idaho, Montana, or Montana. I think it's here.
I think that's right.
Yeah, I don't remember off the top of my head exactly, but yeah.
Do you think one court of appeal is enough for all this?
Okay, that's a great question. One court of appeal is enough. The 9th Circuit is huge. You look in Alaska, Hawaii, it's huge compared to the other circuits. So they're talking about breaking it up maybe, like maybe right here. So Southern California or maybe here or something, I don't know. So populations roughly measure out. Because it's huge, it's got a big caseload. So to answer your question, all courts are pretty much busy. But it's probably at some point going to make sense to break up the 9th Circuit so they are more efficient, because they're not, they're in such a huge area. And then we have one Supreme Court, right? You only have one Supreme Court. There's always got to stop at one, because you have to have somebody or some court at the top that has the ultimate decision-making power. So from these courts, that's where you appeal to the Supreme Court. All right, let's move on. So now let's start talking about a civil lawsuit. So we're going to go to page 33 here. We're going to use this fact pattern as a case example. And I'm not going to read this to you, I'll just summarize what it's about. So basically, we're talking about a dispute, a legal dispute that could lead to a lawsuit in court, Kasunta. Now, there are different kinds of legal disputes. It could be an automobile accident, it could be a real estate thing. This is a breach contract case. So basically, it's about a life insurance policy that the life insurance company refused to pay. So the people that are involved, first of all, we have Tony Caruso, who ended up drowning. We'll get to that in a minute. He died. And we have his business partner down here, Elizabeth Smiles. They were partners in an environmental consulting business. And as is common in small business, partners will often have life insurance on each other. That way, if one of the partners dies, the surviving partner will have the money from the life insurance policy to keep the business going and to buy out the family of their deceased partner. So here's the basic scenario. Tony Caruso was down at the beach. He'd gone out swimming. He didn't return for dinner. His wife, Karen, went out and looked for him. They couldn't find him. But they did find his dog, right here, Blue, tied to an old picket fence down by the ocean. His shoes and clothing were piled neatly nearby. His wife searched, and friends searched throughout the evening. They couldn't find him. A little past midnight, his body washed up ashore. He was deceased at that point, his lungs filled with water. Local doctor concluded he had accidentally drowned. Right? So that's kind of the factual scenario. So to cut to the chase, Elizabeth Smiles, who had the insurance, his partner, filed a claim with the insurance company, Coastal Insurance Group, for $2 million. That's the policy for accidental death. In other words, the contract for the insurance requires they pay $2 million if he should accidentally die. After they filed the claim, the insurance company wrote a letter back, saying the bottom paragraph here. After a thorough investigation, we have concluded that Anthony Caruso's death was an act of suicide, which is not accidental, it's intentional, right? The claim is therefore denied its entirety. So in other words, they're saying it was not an accidental death, therefore they don't have to pay. In the real world, suicide is typically not covered under an insurance policy, life insurance, right? It's an excluded event. So that's the basic fact pattern. So now, Elizabeth Smiles is of course mad because they're not paying the $2 million life insurance. So she then comes to see, we now have a law firm, okay? All of us. I get to be the head lawyer. So what's our law firm? What are we going to call it? How about Dewey, Cheatham, and how much? Right? Dewey, Cheatham, and how much? Okay. LLC. Or LLC. All right. So she's now our client. So we are going to try to help her get the $2 million from the life insurance company. We're going to try to resolve this dispute that she has, which could lead to a lawsuit with the insurance company, right? So now, let's talk about how we might go about doing that in the real world. So that leads us to page 26. Okay, 100%er, fill the blank question. What are 6 methods of dispute resolution? I don't remember if I told you guys this, but if you guys want to take pictures, that's fine. I know some here, I obviously don't remember taping it, but a lot of students take pictures of my notes, that's fine. So feel free to do that if you want to. All right. So, what's going on with this page? This page is a list of what we call alternative dispute resolution methods. This is abbreviated ADR. Very common. This is becoming the trend in the law. The trend in business is to utilize these methods to resolve mostly civil, but some of these also apply sort of to criminal, but primarily civil lawsuits. So let me start with that word alternative. An alternative to what? Any guesses? Alternative to what? An alternative to litigation or a lawsuit. In other words, these are methods that are intended to help you resolve a dispute without using a formal court system and going to a trial and all of that. Okay? So an alternative to litigation or a lawsuit. Now, why? Why not just go through the formal court system, have a lawsuit? Why? Why have alternatives? What are some reasons?
Takes longer.
Okay, takes longer. So time, absolutely. Typical lawsuit, like in an automobile accident or something. Yeah, it depends where you're at in the country, but like here in Polk County where we're at, you're looking at about a year and a half from the time you file the lawsuit, depending on the courts, you know, how backed up they are. It's like a year to a year and a half to get to a trial. Some places, maybe several years. I had a friend once that was a lawyer in Chicago in Cook County, and at that time he told me it was about a 5-year wait to get to a civil trial. 5 years. I mean, it's crazy. So I don't know what it is now. I haven't really looked. So time. In addition to that, the court system is set up. We have procedures that have timelines. So like I file something with the court, and then you have 30 days to respond. And then I've got 30 days maybe to respond to you. And then you've got 14 days back, and it just all depends on the procedures. Federal court's a little different than state. And so that creates time lag. So time, why else? Time, and what's the second one? Money, right? It's expensive to go through the court system. You have to pay filing fees to file the lawsuit with the court. Those filing fees are based on the value of the case, which can go up and up and up. You got to pay attorney fees for lawyers. You have, we'll talk about discovery here in a little bit. You have discovery costs, investigators, and depositions, and just lots of expense. So time, money. Is there another reason why you may not want to use the official court system?
Public record.
What was it?
Public record.
Public record. Public record, yes. So maybe, you know, the people are well known, they're famous or something, they don't want all their private information out there. Or maybe you have a secret formula, like it's a breach of contract, and I don't, like my secret barbecue sauce formula. And in my restaurant, I don't want it out there in the world. Goes to court, it's public record, right? So maybe it's a chemical compound, patent, or electrical thing, design where you don't want that out there, it could be copied. So yeah, time, money, publicity. And there's one more reason, which I'll just tell you, is that our court systems are set up to be what we call adversarial, meaning it's me against you, right? As opposed to, hey, let's work together to solve a problem. So they're not very cooperative, they're more based on kind of a sports model where it's one team against the other team. And so that's not always necessarily the best way to resolve certain types of disputes, especially involving families, kids, after people die, their estate, having the children argue with each other, and it gets to be kind of ugly. So there are other ways to avoid that, that whole system. All right, so on the test, what are some reasons to avoid going to court? Time, money, publicity, adversarial. Okay, time, money are the two big ones. So in other words, these mechanisms are typically going to be quicker, cheaper, private, and less adversarial. Attention. All right. So let's start with number one, settlement. Question.
Oh, it's not a question. I have to be somewhere at like 6:15, so I'm leaving at 6.
Did you get the sign-in sheet?
Yeah, they are.
Okay, you're good to go.
All right.
All right, settlement. So let's start with number one, settlement. So when I say settlement, most of these methods, not all of them, but a lot of these methods are designed to lead to settlement. That's like the end goal. That's what you're trying to accomplish. So when I say settlement, settlement is basically a contract, an agreement between both sides to a dispute on how to resolve the case. Now, it may be a facilitated settlement through mediation. It may be directly negotiated by the parties. It may be imposed upon you by an arbitrator in a non-binding arbitration. There are various different ways. So there's a couple things I want you to know about a settlement. All right? First of all, most cases get settled. I don't have any statistics on this, but in my own practice, I've been practicing since 1991, easily 90% of the cases I'm involved with have settled. Maybe it's higher than that, right? And so that's both criminal and civil. I mean, cases usually get settled. So most cases lawsuit never even gets filed in a civil case. So I have a little phrase down here I want you to know, bottom. A case can be settled at any time. Now I put that up there. There's some exceptions to this, but the idea is that if the parties are willing and they can reach an agreement, typically speaking, there's nothing that's going to prohibit them from settling their case. Now, that could be before a lawsuit's filed. It could be after a lawsuit is filed and you're waiting for trial. It could be the day of trial itself or the night before. It could be in the middle of a trial. You break for lunch. I had this happen once, 4-day jury trial. We're on the second day. I went out to lunch with the other lawyer that I was against in court. He was actually a friend of mine from law school. And we went to Teriyaki Bowl and settled the case at lunch. Went back, told the judge, and the judge said, great, dismissed the jury, and we read it into the record. So, middle of the trial. After the trial, you're waiting for appeal. You can settle. After an appeal, waiting for the next level of appeal. You can settle all the way up, even to the Supreme Court, or even after the Supreme Court. So, basically, there's not going to be a barrier to settlement. In fact, most judges will encourage settlement. With that said, it gets harder the longer you go to settle a case because you have more expense. And the only way you can recoup it is to really settle or win the lawsuit. So that's one rule I want you to know, okay? Now typically, when you reach a settlement, you will put together, depending on the kind of case, a settlement agreement, or sometimes we'll call it a release agreement, or sometimes it'll be both, a settlement and release agreement. And basically that's a contract where both parties in writing agree that how they're going to settle the case. Usually it involves a payment of money from the party that did something wrong to the party that was harmed. And in exchange, the party that was harmed releases the other side from any liability. So like an automobile accident, right? Maybe somebody ran me over with their car and they broke my leg, so I sue them. So we reach a settlement. Their insurance company is going to pay me maybe $100,000 for breaking my leg. I take the money. In exchange, I release the person that ran me over from further liability. So, very important document. A couple things for you guys. Number one, if you are the injured party, never sign a release until you know the extent of your injuries. I have had cases where, one that I remember in particular, a lady was in an automobile accident. Basically, she got T-boned, hit on the side, and then her head hit the window of her car. And she went to the emergency room, and she had some, neck injuries. And basically, they just said it was soft tissue injuries. So, about a month later, she settled the case with the insurance company. It wasn't for a huge amount of money. And then, like a few weeks later, she started developing these really bad headaches. And they were just excruciating. And then she started losing vision in her eye. It got really blurry. And then it just basically was just a halo. So she lost her vision in her eye. Turns out that when her head hit the window, it bruised her brain. And she had internal bleeding in her brain. And it was swelling. And so she ended up having severe brain damage because of that. Well, she'd already settled and released the other driver from all liability, so she couldn't go back and reopen it. And so the idea, I want you just to keep in your head that before you sign a release, make sure you know what your injuries are and what your future medicals are going to be, or at least have a good idea. Flip side, if you're the party that maybe did something wrong, like you blew through the stop sign and ran into somebody, it was an accident, if you settle with them, make sure you get a release, right? You pay them money and you don't get a release, they can turn around and sue you. That's the whole point of settling. So, all right. So let's move on to the next point here, and that's negotiation. So of all of these techniques, negotiation is the most common, by far, in a way. When I use the term negotiation in this class, what I'm referring to is direct settlement communication between each side without anybody in the middle. If somebody's in the middle facilitating it, we call that a mediation. I'll get to that in a minute. So it may be two parties to a dispute, two business owners, they work it out between them. Or maybe they're lawyers negotiate, like in a divorce case or a breach of contract or an automobile accident. Nobody in the middle, it's the two lawyers representing each side. Or maybe it's a lawyer negotiating with the insurance adjuster. Or maybe it's two sports agents or literary agents negotiating a book deal or a sports contract or something. In other words, there's nobody in the middle. So direct discussions between both sides. That's what I'm getting at. Again, it's the most common. Now, typically, a negotiation will begin with what we call a demand letter, or a notice of claim, it may be called, or some kind of a letter that serves the same purpose, that basically you send to the other side and you describe the legal claim that you have against the other party and that you intend to sue them, and you will settle, and then you put a dollar amount out there. Right? We'll settle under the following conditions. That's usually sent to the other side directly, or to, if they have a lawyer, you send it to their lawyer or their insurance company. So in our case with the life insurance, let's go back to that for a minute. So basically what I would do in that case, if she came in to see me before I ever filed a lawsuit, right? The first thing I'm going to do, I'm going to send a demand letter to the insurance company. And in that letter, I'm basically going to say something like, I represent Elizabeth Smiles. She is the policy holder on the insurance company with with Anthony Caruso as the named beneficiary. The policy's for $2 million, which has to be paid upon accidental death. Our investigation has determined that he died accidentally by drowning. Enclosed is a copy of the doctor's report that examined him the day of his death. That concluded he died accidentally. There's no other evidence that we have to show to the contrary. Therefore, you are obligated to pay $2 million. We are therefore demanding that you submit a check payable to my trust account for $2 million, and you must deliver it by Monday, January 27th or whatever, by 5 p.m. If not, we will sue you. When we sue you, if you do not settle, we're going to sue you for the $2 million together with attorney fees and costs and interest. And we're going to also ask for bad faith of 3 times the amount for your failure to pay under clearly accidental death evidence. So bad faith, right? It's a punitive damage. So that's going to be my demand letter, something like that, right? Okay, so I'm going to send that to the other side, either their lawyer or to the insurance company directly. So that leads me to the bottom of this page again. And I have a little rule. John's rule of negotiation. Do not bid against yourself. And I know that sounds so obvious, and it kind of is, but I see this happen a lot in the real world, and you don't even realize it's happening. So let me show you what I'm talking about. Do not bid against yourself. All right, so this is kind of a goofy example. I have a farm just north of town here, and I used to run cattle. And typically, about this time of year, when the grass started growing again, February, early March, I would go to, back then I'd go to Corvallis to the auction yard, and I would buy calves, baby calves, bull calves and heifer calves. And so I'd go to the auction, so like let's say I'm at the auction, let's say this is a calf, this is a cow, right? 300-pound calf. So I'm at the auction. So the auctioneer's going, okay, we have a calf here, 300 pounds. Do I hear $300? $300, $300. So I raise my hand. Okay. So I'm now the head bidder. $300. The auctioneer says, okay, $300 to the guy with the ugly blue tie.
No, it's nice.
The guy with the blue tie. Thank you. So $300. Okay, do I hear $350? $350. So I raise my hand again. Nobody else has bid. Just me. I already got the high bid. So the auctioneer's like, okay, whatever, you can bid against yourself. So the auctioneer's like, okay, fine, do I hear 400? So I bid again. Well, I'm bidding against myself, right? Now you'd never do that in the real world, right? That's obvious. Happens in a different way. Back to my insurance case. So let's say I send them a letter, $2 million to settle. They send me back a letter, and in the letter they say no. So I send them back another letter, and I say, okay, how about 1.9 million? And they write me back a letter, and they say, niet. I'm like, okay, how about 1.8 million? 9. I spelled that right. German, right? Okay, how about 1.7 million? None. French. What's going on there? I'm bidding against myself. This is not negotiating. This is them laughing at me. They're giving me a language lesson, how to say no in 4 different languages, right? And they're laughing at me because that's no different than me raising my hand at the auction. No different whatsoever. I'm not getting anything in return. Negotiating is getting offer, counter offer, counter, back and forth until you settle. So, I see this happen all the time. This is actually a taught technique. I'm not so sure I'm not sure the right word, ethically or morally valid, but it's definitely out there in the real world all the time. I see this in automobiles. I see it in real estate transactions. I see it in business transactions. I see it all the time. Okay? So what do you do if this happens to you? I sent a letter, $2 million. They said no. You're going to cut it off right there. I'm going to send a letter back, and I'm going to say, I received your rejection of my settlement offer. I would phrase it that way exactly. Number one, make clear that I made a settlement proposal, and number two, that they're rejecting it, so later on I can argue that's bad faith. Then I would write. However, in the interest of settlement and in good faith, I will hold our offer of $2 million open to let you reconsider your rejection until Friday, 25th of January at 5 p.m. Pacific Standard Time, at which point it will be null and void unless you have accepted it. I will then be suing you on Monday. You therefore have three options. You can reject, you can accept my offer, or we will entertain a good faith counter offer, but we will not bid against ourselves or negotiate against ourselves. And then if I have not received a response by Friday at 5 p.m., I will be filing a lawsuit on next week. So I'd say that's what I would do, something like that. And then at that point, I'd probably get a letter back with a settlement proposal. It's probably going to be a lot lower than I offered, and then we just start negotiating. So true negotiation, don't bid against yourself. That's my point. I see it all the time. I'll leave it up to you if you want to engage in this type of stuff. That's up to you, but you get my point. Next time you buy a car, you'll see it coming right now, right? Sorry, I can't match that offer. Can you give me another offer? No, I can't match that. That's what the dealer's going to say to you, right? Say, oh, I made you an offer. You make me an offer back now. And we'll go back and forth. Okay. I have another little technique while I'm on it. I call it getting to yes. So let's say, this works, I do this a lot in union contracts, but let's say there are 5 issues, divorce, in many different kinds of cases. Let's say there are 5 issues in dispute, okay? 5 issues that you've got to figure out. Child custody, who pays the debt, parenting time visitation, spousal support, child support, so 5 issues. So what I try to do is say, okay, what issues can we agree on? And let's get those off the table. And then the ones we can't agree on, now we can focus on negotiating those. Now why do we do it that way? That makes obvious logical sense. Well, it helps foster settlement, because now you've agreed on certain points, which shows, yes, you can reach an agreement. And it also gets those issues off the table. And that way you can focus on what's really in dispute. So, again, just throw that out there. If you ever had a chance to take a negotiation class, I highly recommend it. Because there are techniques that are structured like that. So let's go on number 3 and 4. So 3 and 4, mediation, arbitration. These are 2 very, very popular and common alternative dispute resolution methods that are becoming sort of the standard nowadays, especially in areas of family law, like child custody, and in business law, especially in contract law, real estate, business contracts, sales contracts, etc. So I want you guys to know the difference between these 2. It's pretty straightforward. So first we have mediation. Mediation is where you have, these are my 2 parties in dispute, pi and delta, okay? Plaintiff and defendant. So a mediation is where you have a third party in the middle. A third party, called a mediator. And their job is to work with both sides to try to broker or work out an agreement. Sometimes we call it an intermediary, right? In between the 2. Now the third party, the mediator, is neutral. They don't represent either side. Their lawyers may be there representing them, but the mediator's job is not to represent either side. The mediator's job is to work together with both sides to try to reach an agreement, a settlement. Now, the mediator may suggest settlement ideas and give you advice on outcome and who they think, is going to prevail, and maybe dollar amounts and all that. But they're not gonna tell you what you have to do, nor, and this is what I want you guys to know, the mediator, if you cannot agree, will not make a decision and force you to do it. It's up to the parties to reach an agreement. The mediator will try to help you, but they're not going to tell you, you win, you lose. Right? If they cannot reach an agreement, then they go to court or arbitration. So mediator, third party, will not make a decision. You've got to settle. Yeah.
Usually like an established timeline on mediation.
Okay, that's a great question. The short answer is yes. It may be indefinite. It may be like, okay, we're going to do 5 sessions of 2 hours of mediation. It may be we agree we're going to mediate for 4 hours. And if we haven't reached an agreement by lunch, then we're going to break it off. I've been in, I did a union deal once where we said we're going to go to nonstop mediation and we're going to lock the doors and not leave till we've settled. It took 28 hours straight, yeah. Lots of Subway sandwiches and pizza and donuts and coffee. Right? So mediation, neutral third party will not make a decision. Okay, arbitration is different. Question?
Mediation, I know it's super common with people going through divorce.
Yep,
Beforehand, you're already working with lawyers commonly.
yep.
How does that work when you go to mediation? Is that, do your lawyers come with you, or?
Okay, typically no. For like child custody, typically the parties will meet with the mediator on their own. They don't, but it is also common for the lawyers to go too. But usually, for the most part, they go without their lawyers. They don't usually meet at the same time necessarily for various reasons. One, they may not like each other. But I will tell you, yeah, that's called court annexed or court mandatory mediation. In Oregon, it's mandatory to have mediation when there's child custody issues in family law. Frankly, I think it works great. It gives the people a chance to, how do I say this, air their gripes or their concerns to a neutral third party and then try to work out together what works best for everybody, as opposed to going to court and just, duking it out. So, yeah, we also have mandatory now for some other types of cases, sometimes in estate law with probate. Very common in contract law and real estate to require mediation if there's a real estate dispute. So, yeah, arbitration. So I want you to know the difference between arbitration and mediation, okay? Arbitration. Arbitration, you have a third party that will act like a judge. Act like a judge and make a decision. I apologize for my bad handwriting. Okay? So arbitration is basically like a private trial, so to speak. And the idea is that the arbitrator will hold what we call an arbitration, which may be very formal, almost as formal as a real trial with a real judge in a real court. You may have witnesses, present evidence, the lawyers will make arguments, they'll object, just like you would in court. It may be very informal. In fact, it may be done by Skype over the internet, or literally submitting emails and not having a meeting at all, or a telephone conference. And then the arbitrator will make a decision. So, arbitration versus mediation. No decision. If the parties cannot reach an agreement, then they basically go to court. Arbitration, the arbitrator will review the evidence and then make a decision. Now, sometimes that decision is final and binding. It's called binding arbitration, one and done, essentially. Sometimes it's non-binding, which means you can either go to court from there, or you can appeal it. So that's usually going to depend on the type of case. Most contract law will have, most contracts now will have an arbitration clause, a paragraph that requires arbitration. And usually it's binding, one and done, okay? So you'll get one bite at the apple. All right, so what's the difference? Mediation,
Private judge,
private, no decision, right. Arbitrator
yes.
will make a decision. That's the difference. Now, the rest of these, I'm not gonna really hold you to. It's the first four I want you really to know. But let's just go through a couple of them. So number 5, med-arb, that's not medical. It's mediation hybrid with arbitration. This is a really common technique where the parties in a dispute will agree ahead of time that they will try mediation first. So we may agree for 4 hours in the morning from 8 a.m. to noon, we are going to mediate. The mediator will meet with both sides, try to work out a deal. And then the agreement is that if we don't reach an agreement, at 12 noon, we're going to break for lunch. We're going to come back at 1:15. And at that point, the mediator will switch hats and become an arbitrator and make a decision. Now, the reason why you do that is it puts pressure on the parties to agree during the mediation phase so they can work out the agreement themselves, because they may not like what the arbitrator decides. I mean, both sides may hate it, but too bad. It's a decision. You got to live with it, right? That's really common, actually. You see that a lot in contract law, especially real estate deals. All right, number 6, court annexed or court mandatory mediation and arbitration. This is becoming standard across the United States. And this is basically where a judge will require the parties, before they can ever go to trial with the judge, to first go through mediation and or arbitration. So I talked about this earlier. Child custody and divorce has mandatory mediation. A lot of union contracts have mandatory mediation requirements before you can go on strike or whatever. Mandatory arbitration in Oregon we have for civil lawsuits that are less than $50,000. Before you go to a trial, you got to go through arbitration first. Now again, the idea behind this is, number 1, to cut down on court cases. So the judge doesn't have to cut down their workload, but also is an opportunity to try to resolve your cases privately, outside of the adversarial process. All right, now the rest of these, I don't really care that you know so much. These are all pretty much variations of arbitration or mediation. So for example, you might have what we call a mini trial or a summary jury trial or a private trial, where you might even have a private jury. There are companies that will, for a fee of course, have a jury, and you can go have a private trial. Those are usually high dollar cases, and they want them to be private because you spend a lot of money doing that. You might have a panel of experts that will review a case and decide the outcome. That's really common in large construction projects like skyscrapers and whatnot, where you'll have a panel of an architect, a civil engineer, a structural engineer, and the parties all agree that they will resolve any disputes instead of going to court. So you get the idea. I won't really test you on those, so you don't really need to worry about them. All right, so the big ones I want you to know are these first 4. And then again, I want you to be able to list up to 6 methods of dispute resolution. Anything off this page is a good answer. So now let's switch gears a little bit and back to my case involving the life insurance and Anthony Caruso. So let's say that we weren't able to settle the case with the insurance company. So now what are we going to do? We're going to sue them. So now let's switch gears and start talking about a civil lawsuit, okay? So go over to page 27. So these are the basic steps in a civil lawsuit or civil litigation. Now, you don't need to know all these, don't worry. CADTVA, that's right, they want you to know. Complaint, answer, discovery, trial, verdict, appeal. But we're going to go through a little bit of these in detail, some of them not so much detail. So first of all, talking about the trial court process, what happens in a civil lawsuit. Now, I get asked this question sometimes, why are you teaching about a lawsuit in business law class? It's not trial procedure, it's not litigation class, it's not evidence code. Who cares, right? It's not business. Wrong. In America now, litigation is a part and parcel of business, especially medium and larger sized business. And it's highly likely, even if you're not the party in the lawsuit itself, you may be involved in a lawsuit or part of the litigation process at some point in your career. Now, it might be something like you're working for the bank, and the bank gets a subpoena for records for a checking account for a divorce case. You now have to compile those records as the representative of the bank. Or, like I told you earlier, I used to be in-house counsel for a trucking company, right, here in Oregon. And part of the reason why they had me in-house is they had constant, this is true for almost any medium to large-sized corporation. I mean, some legal issue literally once a week, if not daily. And so part of my job was, if there was a lawsuit, was to prepare the employees to respond to discovery requests, deposition, get ready for trial, to file documents with the court, to arrange for lawyers in other states as necessary. And even though the people I worked with in the company, they weren't involved in a lawsuit, they wouldn't maybe have to testify in the trial. So the point of this is I want you to know a little bit about how a civil lawsuit works. Even if you're not going to go to law school, you're likely to be involved in that process at some point, typically before the trial, during the pretrial stage. So that's why I want you to know a little bit about how this works. And then, of course, if you ever do get sued, you kind of know what is going to happen, the process. Now, back to my case involving the insurance company. So let's just work our way through here. So first, we're going to try to settle the case with the insurance company. We might negotiate first, we might try mediation, we might do an arbitration, but let's just assume none of those things worked or we didn't do them. And so now I'm going to file a lawsuit for Elizabeth Smiles against the insurance company. So first step, number one, I'm going to file a complaint at the courthouse as her plaintiff's attorney. So that will start the lawsuit. So the complaint is the document that starts the lawsuit. That's a test question. What is the purpose of a complaint? To start a lawsuit. Okay? A complaint is what we call a pleading. Pleading. The plaintiff files the complaint. Now I want to show you another page. Page 29.